everybody. I think I'm close the windows because it's still very early in the morning and the taxis are out here buzzing and buzzing. Let's try this again. That's better. Morning. Hi everybody. Afternoon, evening, whatever time you are watching this. Anyway, welcome to another video on my channel. I know it's been a minute and 2 seconds and it's been a while. Sitting in front of you, for those who don't know, is Mapula Satusa. So I'm an attorney and I have been procrastinating to say I'm not straight. I feel like I'm not straight. I've been procrastinating to make a video because I wanted the next video to be me taking you guys to court and you guys getting I'm getting too light for you guys to get the court experience. But as we all know, and as I think I've explained before, things are done virtually now, and especially in the high court. In the magistrate court, we do go to court. I'm going to insert a picture of me at court. That was at the magistrate court. We were there for a judgment. But at the high court, we don't run trial at the moment because of the COVID situation. So I just figured if I wait for the day that I'm going for trial, then I'm going to wait forever because things are a bit slow now. There are directives coming out. We need to wait for them to be out and assessed and read properly and understood. So today I have a trial that is going to be running virtually. So I'm just going to take you guys through the process of how it gets to the point where the judge on the other end and me on this end are able to run a trial in that fashion. Okay, so I'm just going to be explaining how we run a virtual trial. So the court in Gauteng has come up with a system where you can upload documents on the system. So previously, let's say I am the plaintiff and I want to lodge summons against somebody. I'll obviously do my summons, print them, 3 copies. I go to court physically. I go to court. I get a case number. After getting a case number, I'm going to give the sheriff 2 copies. The sheriff is going to have to go physically so the sheriff is going to go to the defendant, serve, give you back your copy. You're going to make another copy, take it to court to show that it's been served. And once, let me take these off, I can't see that. But once once that is done, that's how you guys are going to proceed. Then they are going to send you a notice of intention to defend, and then they're going to give you a copy, then they're going to take their other copy to court, so and so. Then they're going to file their plea, they're going to give you a copy, then they're going to take one to court. So now that court has been erased, they're saying, we don't want anybody in the court building, stay at your offices. They have come up with a system where they saying that you have to upload whatever it is that you are serving. So now service is much easier and filing is much easier, but it doesn't mean you can just serve it at any point. The time limits still work, they still apply, and just because you have uploaded it on the court system, that does not automatically mean that you have served it onto your plaintiff or your defendant. You will have to serve it or CC the court and the defendant. And if you're the plaintiff or if you're the defendant, you have to CC the court. This guy is so loud. So just like that, that means you have to serve it. You have to put it on the system. You have to serve it on the email that they provided you from court, and then you have to also serve it onto the plaintiff or the defendant. So that has really helped in the fact that you can literally run your matter paperless, because you don't have to print for the court file, you don't have to print for your opponent, and you can just do the documents on your computer and then save them in a folder, and then you just send it to that one, send it to that one, file it there, and you still have the copy on your PC. So that's one benefit about it, is that it saves time and it saves paper. So because you would have been posting or uploading your summonses on the system, then they upload their notice of intention to defend, or we upload it as the plaintiff. Basically, the same way that you run a trial, where when you're about to run trial, the plaintiff is the one, because the plaintiff has to do everything. As a plaintiff, you do all the work because it's your matter. You are the one claiming, you are the one wanting money. You need to make sure that things are running smoothly in court. If the court needs the court file needs to be accurate, perfect, and the judge needs to know where everything is. So the same goes on to the system that the court has developed, is that the plaintiff has to make sure that after the defendant has given you those documents, you also put them in there to say, this is the defendant's notice of intention to defend, the defendant's plea, the request for further particulars, all of that, the discovery. You need to put it properly so that when you run in trial and you are referring to something on the file, you are able to refer the judge to the specific folder on the system to say, okay, you guys created this case on the system. The judge is going to open that case, and then he's going to look, is there a summons? Yes. Is there intention? Yes. Is there plea? Yes. Is there discovery? Yes. Is there experts? Yes. Is there this? Yes. Page 5.3? Yes. All the notices that you're supposed to do, all the documents that you're supposed to do, and then only then, when the judge is satisfied that the court file, because that basically replaces the court file. Once the judge is satisfied that the court file is up to scratch and it is fine and pleadings are closed, everyone has discovered, everyone has submitted the documents that are relevant to the trial, then the trial can proceed. Just the same way the judge is going to go through your file if you are in court physically, and he's going to ask you, why isn't there this? Why isn't there that? And then he's going to remove your matter if your matter is not up to scratch. Same thing there. If you haven't uploaded something as a plaintiff, your matter is removed. And the defendant doesn't care if the matter is removed. You care because you want your client as a plaintiff to get their money, to get justice. So them removing a matter for you is a big no-no and a big setback for your matter. So basically that's what's going to be happening. Oh, and then once everything is done, once you guys have had a pre-trial, all these litigation prerequisites that has to happen have happened, and you guys are at the point where you guys are running trial. Guys, I don't know why my voice has become so husky as of late. Yeah, anyway, I don't want this video to be long. Once that is done, then you're gonna get a trial date, and then once you get a trial date, your matter is gonna get allocated to a judge. Then the judge or the judge's secretary is gonna send you a link, either a Zoom link or a Microsoft Teams link, where you guys are gonna be doing video conferencing. That morning, the secretary is going to call you or send you an email to say, here's the link, please log in at 10:30. Your matter is number 17 on the roll. The judge is going to hear your matter then. Then you know that at that time, that's when your matter is going to be called, that's when your matter is going to be heard. If you are not there to hear the matter, let's say you're having some connectivity issues at the time when you were supposed to log on, normally normally the judge will stand your matter down, which just means that You're just going to take that matter and put it at the bottom of the roll. So if you are number 17 and there's 170 matters, yep, you're going to have to wait for those matters, unless he, while he's busy with the matters, will say, that matter that I stood down, are the plaintiffs and the defendants here now? And then you'll say, yes, your worship, yes, my lord, sorry about that, we were having some connectivity issues, and then they can hear your matter. So that's basically what's going to be happening today. I am fully prepared for my trial. It is a personal injury trial, and it's a personal injury claim, sorry. And liability has been accepted. General damages have been granted. We have been given an offer. So right now, what myself and the defendant cannot reach an agreement on is the loss of earnings. That I'm saying that because of this accident, my client is going to lose out on this much. The defendant is saying, nah, it's not that bad, he'll lose out on this much. You guys know the shebang. So yeah, so basically that's what happens in a trial virtually. I don't know if I should because I'm thinking, should I record myself while I am on the trial? But the thing is, I'm gonna have to mute it, and I can't record the screen where the judge and other attorneys are. It's not allowed. So basically, you still wear the same way that you would wear when you go into court, hence I'm wearing black and white. You're still going to have to put on your robe and your bib if you do have one. I don't have one. I just put on my robe, and you address the judge. The only difference is that you're going to be sitting the whole time, okay? And whereas in court, when the defendant is speaking, you sit down. When you want to speak, you stand up. When the judge is speaking, you sit down. So now everybody has to sit down, because you can't be going with your, as a court pieces, your worship. No, you need to be in frame and the judge needs to see you. So basically, that's what happens, guys. I'm not going to record it because it's going to be so boring. It's just going to be me in my headset looking at my laptop and trying to argue my matter. So, yeah, I just wanted to share with you guys how a trial is run virtually. Another benefit of trials being run virtually. When I was a candidate attorney, guys, let me tell you, most of the attorneys, I was a candidate, I was still a student, I was a clerk. Most of my seniors as attorneys had never run a trial in front of a judge before, because the anxiety, the nerves, the anxiousness when you are in court and there's other people in there, your colleagues are there, you don't want to embarrass your client, you don't want to embarrass yourself, and everybody is just sitting there. And let me tell you something, the judges will embarrass you. And sometimes they don't do it intentionally. Sometimes they just ask you a question that maybe you did not expect, and you start to mumble, and you starting to look through your file, and you're starting to look unprepared. Your client is there, your colleagues are there. It's so embarrassing, your palms are wet. So most of the time back then, the attorneys always appointed an advocate to appear, because an advocate specializes in going to court and speaking in front of the judge, and knowing how to take that embarrassment with a cold shoulder. They know how to handle it. They know the pressure. They know what the judge is going to ask. And us as attorneys, we mainly do the administrative part of the work. Okay, we issue the summons, we figure out what the legal issues are, what the problem is, how we can get to what we want. And if we're not able to reach settlement, then you guys can brief and some other attorneys brief and advocate. But if you feel like you can run the matter as an attorney, then kudos, go ahead. And that's what I'm saying, that right now at our firm we don't really appoint advocates right now that much. If you are able to appear, you are able to argue your matter precisely and properly, then you can sit in front of a judge and argue your matter. I haven't been an attorney for that long, but this process of us doing things virtually has really boosted my confidence. It also helps me when I go to the magistrate court, because magistrate court, as I said earlier, is still run the same. You still go to court, you still, things are still normal. So me going in front of a judge in the high court has boosted that confidence, even though I'm going to the high court in my office, but just to sit there and that may be my link for my trial. But I'm blabbering right now. I don't want this video to be longer than 20 minutes, and I hope you guys have learned something from this. You guys can understand what it means when we're saying that we are holding a trial virtually. It's not just like, what does that even mean? So yeah, guys, that's it from me to you guys. If you're new, don't forget to click that red button that says subscribe. If you want to be notified every time I upload a video, do click on that bell thingy, notification bell, so that you get notified every time I upload a video. And don't forget to follow me on my social media platforms. I am Mapula_Situsa absolutely everywhere. Everywhere meaning Twitter and Instagram. And I'd really appreciate it if you guys would follow me there and leave your comments down below on what you'd like to see, who you'd like to see, and what you'd like to hear. From me to you is kudos.